Lady, before I resume where I left off, may I mention a point of housekeeping? I've listened with care to the 3 submissions you've heard so far, and I'm not entirely sure which bits of Mr. Allen's analysis of the development of the European dimension, as I shall call it, and of the underpinning non-statutory material for the 1975 Act is challenged. Lest it is, I wonder if I may use my own discretion with his agreement as to whether I give him more or less time.
It's entirely between the two of you.
Thank you very much. To take up then where I did in fact leave off, and to answer the question my Lord Hughes asked, which was, as I recall it, to give examples or to explain how it would work if cases were proceeding with similar or the same facts in different jurisdictions. That's very common in the Employment Tribunal, and there is a developed practice to deal with it. For example, and this is but one example, unfair dismissal is a statutory remedy with, unless discrimination is alleged, a cap of £25,000 on the recoverable compensation. Wrongful dismissal is a contractual claim with no such cap, subject to the terms of the contract. It is not uncommon for people to issue those different claims in different fora, and the practice has developed whereby one shall give way to the other. Now, you have, I think, in the literal sense of the word, a plethora of authorities before you. You don't have the 2 I'm about to mention simply for the purposes of your note, because it's in specific answer to Lord Hughes's question. I apologise for that. I, of course, undertake that we will provide them very promptly. For the purposes of your note, the Court of Appeal has considered the guidance as to which forum should give way to which, in a case called Halstead and Payment Shield, all one word, Group Holdings Limited, 2012 IRLR 586. And as between the governing jurisdictions, I may provide you, with your permission, with a case called Vaughan and the London Borough of Lewisham, 2013 IRLR 720, when the High Court stayed a claim for harassment and defamation where it covered the same grounds as the claimant's employment tribunal claim. It is not an unmanageable problem. I'll return, if I may, to the point I was developing before the short adjournment, which is the codified structure of the rules of proceedings of the Employment Tribunal. These you find in Authorities Volume 12, and the first page to which I shall invite your attention is MS page number 882. There are numbers in the top right for those working on hard copy. It's page 5 of the Employment Tribunal's Constitutional and Rules of Procedure Regulations 2013. Regulation 8 Would my Lord like me to give...
You said Authorities 12?
Authorities Volume 2.
2?
Yes, you said 12.
I'm so sorry. Fortunately, we
tab
haven't
12. Tab 12.
2 tab
No,
12.
tab
That's
13.
tab 13.
13. Sorry.
It is 213.
Thank you.
Well, third time lucky. I hope it's 882 that you're
It's
looking at.
definitely 882. If you're looking at Regulation 8,
Yes.
which is panels.
I shan't read that out in full, just to make the obvious point that the Employment Tribunal is not a jury. It contains specially appointed people who undergo training and, of course, are more than one in number and bring the aggregate or cumulative experience they have of life and its problems to their duties. The next regulation is Regulation 10 at 894, page number 17. This provides for the power vested in the Employment Tribunal to reject claims, but I make it perfectly clear that it's on formal grounds, no fee, no name, no signature, and so on, and is not particularly relevant for present purposes, so I mention it only to move immediately on to page number MS 902, internal page number 25. (26)(1) As soon as possible after the acceptance of the response, the employment judge shall consider all of the documents held by the tribunal in relation to the claim to confirm whether there are arguable complaints and defenses within the jurisdiction of the tribunal. That's sometimes called the paper sift. It is fair to say that the paper sift is rarely invoked in discrimination claims, but that's for no other reason than that they are fact sensitive. And it is inappropriate, we would say, in the administrative court as in the employment tribunal, if the facts alleged arguably give rise to a right to remedy, to strike a claim out on paper. So
What
there
are you
is no...
looking at? Yeah, you're just looking at the claim form, No, all the documents.
All the documents.
What does that include then?
Well, it will be the precipitating claim form, which will have a narrative.
So it's after acceptance of the response, so it's not based on any evidence or
Well, the claim form
statements.
will contain assertions. There may be a response as well.
Does it have to be verified? It probably does it?
Yes. Well, it has to be signed. I'm not sure it has a statement. of
Doesn't
truth.
have to be verified in the same way that particulars of claim have to be.
No, it doesn't.
But then that's because tribunals aren't bound by the rules of evidence in the way that the courts are.
Quite. Moving on to MS, page number 904, page 27 internally. Regulation 29, case management orders.
Isn't this Rule 29? Because we're into the schedule, which is the rules.
The tribunal may at any stage of the proceedings on its own initiative or on application make a case management order, and it goes on to cover some at least of the bases on which that order may be made. It does not specifically confer a power to stay, but that power is recognised to be available and widely recognised to be available as between, for example, claims issued in different forums. Perhaps most significantly is Rule 37, MS page number 908, page 31. (37)(1) reads, at any stage of the proceedings, either on its own initiative or on the application of a party, a tribunal may strike out all or part of a claim or response on any of the following grounds. And if I may, I shall read only the first, but allow the eye to travel slowly over the others. A, that it is scandalous or vexatious or has no reasonable prospect of success. That is obviously a protection and a powerful one to those who feel that they are in receipt of and being inundated by vexatious claims. Moving forward to Rule 75, MS page number 925, internal pagination 48. That provides the current situation as to costs. Rule 76 enables a tribunal to make a costs or preparation time order where a party or that party's representative has acted vexatiously, abusively, disruptively, or otherwise unreasonably in either the bringing of the proceedings or part, or the way the proceedings have been conducted. There is also the power given by the rules to make what is called a deposit order, which requires literally the deposit of money up to £1,000 as a condition precedent to being allowed to take an argument forward. That is per argument. So if a particular claim has 6 questionable arguments, then 6 deposit orders can be made.
Where is that, please?
Forgive me, my lord. That's Rule 39,
39. Yes, thank you.
page number 909, internal pagination 32.
Are they common, those? Are they common?
Yes.
They are.
Yes. They're regarded as a valuable protection against the mischievous or the speculative. Those rules provide the answer to the fear, if it is a fear, of the qualifications bodies before you that they will indeed be inundated by the unmanageably vexatious. I would say this: they present no evidence that they are or are likely to be inundated by such claims. I'm sure they do not say that those alleging discrimination as a class are more prone to discrimination, to vexatious litigation. And it is in our submission a phantasm which is given the lie by what Mr. Bowers said in answer to my Lord's question of how often the point has been taken, which is not for 25 years or so. There is no evidence that there is a huge cohort of people out there just waiting to inundate or flood, and they've had 25 years to do it. However, I do wish to be entirely clear about what we say is the motivation underpinning the arguments you have heard thus far. And it may be simply stated, it is nothing to do with the respective expertise of tribunals. It is to do with the deterrent effect of costs. To adopt an observation of my Lord Mance, a judicial review can be expensive. The answer to that was, well, judicial review typically takes a day, whereas employment tribunal cases may take many days. But that's not to compare like with like. A traditional, if I may call it that, judicial review application may indeed proceed on the papers. But where it is fact-dependent, it need take no less long than an employment tribunal case. It is also not true to say that typically these complainants are professionally represented and third-party funded. 3 things to say about that. The first is the definition of qualifications body is broad indeed. You happen to have 3 distinguished professional regulators in front of you, but the Public Carriage Office is a qualifications body. There was a time when the Confederation of Registered Gas Installers was a qualification body, and licensing, as in liquor licensing bodies, are too. Not everybody has indemnity insurance or may call upon it. Second, indemnity insurance tends, as the name of the various organizations will tell you, to defend. It is used as a shield against attack, not as a funding source for going on the attack. And third, a qualification body may stop a student at the outset of her career. It may, of course, remove the right to practice of someone of significantly greater age. But it's wrong to characterize the type of people who would wish to complain or may wish to complain about this type of unlawful discrimination as well-funded, well-resourced, or indeed particularly able to be self-represented litigants. The protected characteristic itself may impair their ability to do that last task. And the effect, if the GMC and the first 2 interveners are right, is that that which Parliament has, we say, intended to take place in a relatively costs-neutral forum will compulsorily be moved, whether or not the complainant wants the reliefs available there, to a very expensive, procedurally complicated forum. Now, that is not to say that that interpretation must be wrong and for that reason. But given the underpinning philosophy of anti-discrimination law, it is unlikely that this was Parliament's intention. And that philosophy recognizes, first and foremost, that almost invariably such cases will involve an inequality of arms. By definition, qualifications bodies will be organizations, maybe corporations, maybe charities. The complainant typically will be an individual. There will be a mismatch of resources and expertise. And the point of the European directives, and we say statutes must be read so as to be compliant with them, is, to use a dreadful cliche, to level the playing field. And one thing that doesn't do that is to make it ruinously expensive. My learned friend Miss Callahan elegantly submits that it is not the intention of the solicitor's regulatory authority to deter the meritorious. I'm sure that's right, but it's likely to be the effect because it is perfectly rational to be fearful of being bankrupted by an unsuccessful piece of litigation. And it's likely, or it may be the case, I should say, that in fact the meritorious and rational complainant will be more deterred because rationality and vexatiousness are not common bedfellows. But it surely cannot be said that if these claims were all cost sensitive in the sense of costs following the event, that would have no effect upon the preparedness of complainants to complain about the societal evil that is discrimination. I'll come in a moment, if I may, to the European legislation. But first, may I invite your attention to this Supreme Court Act, 1981. That's as originally enacted, which you'll find at Authorities Bundle, tab 1. May I put that request on hold? It may be quicker to go to Volume 1 of the Authorities, tab 7. MS page number 647. This is in fact a consolidated act. It's not in fact the act as originally passed, but it contains the relevant provisions. Section 29, 1A, which was the original Section 29, provides that the common law remedies will be carried over when, as we said, was the Supreme Court Act, as it was then known, was first enacted. Section 31, which is at MS page number 651, sets out the current range of remedies. They are different from the remedies available as at 1982. However, I do wish to take you specifically to 31 subsection 5, which is at page 3, MS 653. If on an application for judicial review, the High Court quashes the decision to which the application relates, it may, in addition, substitute its own decision for the decision in question. 5A, that power the 5B power, may only be exercised if the decision of the question was made by a court or tribunal. Qualifications bodies are neither of those things, and the power to substitute does not exist in an administrative court challenge to a qualification body action. The significance of that is, we say, when one comes to consider whether judicial review is an appeal which nobody contends, or a process that is in the nature of an appeal, which is the case I must meet. I'll come back to Khan, if I may, but it is important that this court has a correct understanding of what the powers of an administrative law judge, administrative court judge, when a judicial review challenge of a qualifications body decision is heard. He may quash and remit, but we say that is not what is meant by proceedings in the nature of appeal, even using Lord Justice Hoffman's dictum, to which your attention has been invited from Khan, because that is not having the decision reversed by another group of persons. There is no independent element to the decision. There are other reasons for contending that judicial review cannot be caught by Section 127, but if I may, I'll come to those in due course. Those are the observations that I would wish to make as to the Supreme, and indeed, for that matter, the Senior Courts Act, save for this. Section 31(4) deals with the question of damages. This is MS page number 652, internal pagination 2. On an application for judicial review, the High Court may award to the applicant damages, restitution, or the recovery of a sum due if the application includes a claim for such an award arising from any matter to which the application relates, and the court is satisfied that such an award would have been made if the claim had been made in an action begun by the applicant at the time of making the application. That permits the joinder of a private law claim for damages to a public law claim, but only if the public law claim is made, and obviously successful, and it is between the same parties. And that is the point, and I understand that Mr. Allen will develop this further before your lordships and your ladyship. That is the point of the ancillary parties debate, because you cannot judicially review an individual for his actions. If the construction put on sections 109 to 11 is correct, what will actually have to happen is that the ancillary party, normally of course an employee but potentially an agent, will travel to the administrative court with the employing qualification body, but there will be no separate public law claim against him, or as the case may be, her. And as we shall show when we come to the Equality Act, it is an exclusive jurisdictional code. The administrative court has no power to make awards against individuals for breach of the Equality Act. And that, we say, would wholly frustrate the purpose of the provisions of making the individual discriminator, the employee or the agent, liable. For the purposes of your note, but not to take you to it, at volume 1, tab 9, MS 760, you will find the provision CPR part 54.3.2, which stipulates that which is well known, that you cannot just claim damages in the administrative court. You must claim a public law remedy, and you can bring along with that a private law claim if you are so minded. We say, and we have said in our printed case, that that is part of what the 1981 Act tried to do and did in fact do, which was to codify various overlapping jurisdictions and put them under one roof. How you phrase that and how you describe it is possibly a matter for personal taste. For our part, we would not challenge an assertion as made by Lord Justice Morbick, the authors of De Smith, and indeed by the GMC at paragraph 34 of its printed case, that it put judicial review on a statutory footing. One might also, and perhaps just as accurately, say that it regulated judicial review. But it did not create the right to seek judicial review. But one cannot, after all, create that which already exists. And the range of remedies...
Surely it superseded the common law.
Certainly it did.
In that sense, it created a new remedy, differently defined.
Certainly differently termed, and there are, over time, a number of additional remedies that have been added. But
Yes, the origin of modern judicial review is, the basis is statutory.
Yes. That's what I mean by being put on a statutory footing. It's not any longer a common law remedy, albeit that specifically Parliament has carried over the prerogative writs, although the names have changed, into the new era. The point is made when we consider the question of damages, and I have focused thus far on damages and costs for the simple reason that those are the things that are most likely to act on the mind and control the actions of individual complainants. The point about damages is answered in some way by saying that within the statutory appeal process, for example, Section 40 of the Medical Act 1983 as amended, there is absent there too a right to compensation. That's not particularly surprising because that statutory appeal lies against the decision of a statutory panel that would have quasi-judicial immunity from suit. Earlier decisions have no such immunity from suit. Whilst I am on the topic of Section 40 appeals, they are markedly different from judicial review proceedings. They are termed a rehearing. It is fair to say that it is an attenuated rehearing, because it is not common, though it is permissible, to recall evidence, and it is very uncommon, though it is permissible, to adduce fresh evidence, and there will therefore inevitably be a degree of deference to those who have, in the time-honoured phrase, seen and heard the witnesses. And fact-finding, facts found, are very difficult to challenge on a statutory appeal. Nevertheless...
That's equally true in the Court of Appeal.
Yes, it is. That's...
And indeed in the High Court hearing appeals from circuit judges and so on and so forth.
Yes.
That's how appeals are these days.
Yes, but they needn't be, is my point, but they generally are. But the court, as you know, has full power to substitute its own decision on the merits against a final order of a fitness to practice panel of the Medical Practitioners Tribunal Service, to give but one example. And as I hope I've already demonstrated, on judicial review, that power does not exist, even where the power to substitute does exist, that is to say, where the impugned decision is that of a court or a tribunal. It is very circumscribed indeed, and may only be exercised if, but for a mistake in law, there was only one possible outcome. And that, again, shows the philosophy of the development of the Supreme Court Act, now the Senior Court Act, which is to rationalize systems and make them more efficient. May I then turn against that preamble to the Equality Act and start by inviting your attention to Authorities Bundle 2, please. Tab 31, MS 1175. This is the framework directive for equal treatment in employment and occupation. It needs to be read in full, but rather than take your time by so doing, perhaps I can pick out certain provisions from it. Under the recital at paragraph 4, still on 1175, the right of all persons to equality before the law and protection against discrimination constitutes a universal right recognized by the Universal Declaration of Human Rights, the United Nations Convention on the Elimination of All Forms of Discrimination against Women, United Nations Covenants on Civil and Political Rights and on Economic, Social and Cultural Rights, and by the European Convention for the Protection of Human Rights and Fundamental Freedoms. That illustrates the significance of anti-discrimination legislation. Turning to page 1177, paragraph 29. Persons who have been subject to discrimination based on religion or belief, disability, age, or sexual orientation should have adequate means of legal protection. To provide a more effective level of protection, associations or legal entities should also be empowered to engage in proceedings as member states to determine, either on behalf of or in support of any victim without prejudice to national rules of procedure concerning representation and defence before the courts. And at 30, the effective implementation of the principle of equality requires adequate judicial protection against victimization. And at 31, rules on the burden of proof must be adapted. That finds its echo in Article 10, MS page number 1179. That is an indication of the imbalance faced by many of those who face or say they have faced discrimination. It is insidious. It is rarely overt. It is frequently the act of a powerful corporation or employer. And to give effect, or partially to give effect, to the rights of those who claim to have been discriminated against, the European Framework Directive, and subsequently, of course, the Equality Act, have required the burden of proof to be reversed.
That's Section 136, isn't it?
Yes.
Of the Equality Act. I should have asked the others, does that apply universally to discrimination claims or only in employment tribunals as was alleged against you?
It's all courts and tribunals,
That's
so
what I
it
thought,
applies
yes.
across the board.
That's what I thought, yes.
Article 17 is at MS page number 1180. Member States shall lay down the rules on sanctions applicable to infringements of the national provisions adopted pursuant to this directive and shall take all measures necessary to ensure that they are applied. Sanctions, which may comprise the payment of compensation to the victim, must be effective, proportionate, and dissuasive. The word dissuasive there is, of course, intended to connote dissuasion of the discriminator. We say that the statutory construction contended for by the General Medical Council would indeed be dissuasive, but of precisely that cohort that needs protection from such exigencies. The Equality Act, which I have appreciate you have been taken to before, is at volume 1 of the authorities bundle, starting at tab 3. But I invite your attention to NS, page number 407. This provision provides the hook upon which Dr. Michalak brings her claim. It is against what have been called at various stages of this litigation upstream decisions, that is to say, decisions that do not directly affect registration, that are, and Mr. Bowers is of course right about this, but regarded by all parties as amenable to a statutory appeal and therefore undoubtedly oust the jurisdiction of the ET by virtue of section 120, subsection 7. Sections 109 to 11 have been dealt with. If I may, I will cede to Mr. Allen the pleasure of answering Mr. Hare's submissions. Section 113 this is MS 441, says at section 113(1) that proceedings must be brought in accordance with this part. There is no inherent jurisdiction. Any claim for relief based on unlawful discrimination must be brought under this part of this Act. Now, the point is made, and you were taken to it before the short adjournment, the point is made that there are a wide range of forums that have Equality Act business entrusted to them. We rely on that. We do not stand in fear of that observation. We recognize it and adopt it. This is very carefully thought through. The touchstone being, where may a dispute be most expertly and expediently handled? The county court, various first-tier tribunals, all have jurisdiction over some aspects of the Equality Act. But under Part 5, subject to 120, subsection 127, exclusive jurisdiction over both true employment disputes and qualification body disputes is vested in the Employment Tribunal. And Parliament has done that deliberately. It has chosen to include qualifications bodies within the remit of the Employment Tribunal. And one has to ask, if it is true that virtually everything done by a qualification body may be amenable to judicial review, and if that ousts the jurisdiction of the Employment Tribunal, what is Part 5? What is the reason that Part 5 contains qualification bodies at all? Like the earlier legislation in 1975 and 76, albeit using different and contemporaneous terminology, Section 113(3) preserves the right to claim judicial review. And that applies to Part 5 claims as much as to any other part. And that is, we would say, meaningless if the General Medical Council is right, because 120 subsection 7 should, if they are right, read appeals, proceedings in the nature of an appeal, including judicial review, which would render section 113 subsection 3A entirely odious.
Well, we've recently had an example of a claim for judicial review in a discrimination context. The one about approved premises for women, where there was a judicial review claim about the whole policy, And of course, subject to the outcome of that, there would be individual claims brought for compensation, independently of that.
Yes, and
That's a good example of how judicial review can operate in discrimination context.
yes, and it is before the enactment of the Supreme Court Act 1981, it operated in that very way. Tucked away within the body of our submissions is an old example of where a tax statute or a tax provision was ruled unlawful, and the taxpayer who had loyally and lawfully paid that tax had to sue separately to get their money back. Of course, judicial review may lead on to other things, but that does not, in our submission, make it that which it is required to be to satisfy the terms of Section 127. The eye, I hope, can pass quickly over Section 115, which is MS 443, 116, and 117, but they are just illustrations of the fact this is a careful code. 118 is not.
Can you just clarify or repeat why it is you say that Section 113, subsection 3A, would be OTOs
Well, because, my lord,
if Section 120, subsection 7
But it could
embraces?
apply to everything else apart from decisions of qualification bodies.
yes, it could.
So it wouldn't be OTOs.
Right. I mean, that's what puzzles me.
I'm sorry. OTOs in the present context. Yes, you're right.
That's not sufficient for your purpose.
But it wouldn't even necessarily be OTOs in relation to qualification bodies, would it? Because there might be practices which didn't give rise to an individual claim for damages, but which it was in public interest should be declared unlawful.
Yes.
And did I write you down correctly as having said that if the appellants were right, Section 55 wouldn't be necessary? Sorry, Section 53 wouldn't have a place in the Act at all, because there wouldn't be any point in subjecting qualification bodies to the law against discrimination.
No, I hope I didn't.
That's what I think you said.
Oh, well, I said it.
Virtually all qualification bodies' decisions are subject to judicial review. Why have Section 53 at all?
No, the point I was attempting to make is that if it is true to say that virtually all, or perhaps all,
Yep.
decisions made by qualification bodies are amenable to judicial review,
Yep.
nothing's ever going to go to the Employment Tribunal, or very few things are going to go, and it certainly wouldn't be.
I understand that.
So why include in Part 5, which is committed to the employment tribunals? I think that's what you were,
Yes.
That's what you meant.
Oh, I follow. All right.
Certainly what I meant, and I suspect what I didn't say.
That's fine.
Could have been a separate little part of its own, which didn't go anywhere.
Yes, and the draftsmen and prior to that Parliament have turned their mind to the concept of judicial review, have specifically mentioned judicial review, but have not carried through with what the General Medical Council says was their intention by making clear in Section 127 that judicial review was included. Whilst I'm on that point, Mr. Bowers said, and I think he recognises, that there is absolutely no parliamentary material to say that this was intended by Parliament, nor is there anything such as a Law Commission report that suggests this change in 1982. But he also said that there was no material on which the converse could be shown, namely that it wasn't Parliament's intention. If I may, I'll take you to the introductory notes to Section 120. They are easiest found, I hope, in the supplementary bundle within the body of the submissions of the EHRC at MS 3245. Paragraphs 32 and 34. Supplementary bundle, first tab, written case for the third intervener, paragraph 32, MS 3245. Certain features of the long title are excerpted there. It starts in the first boxed passage, an act to reform and harmonise equality law and restate the greater part of enactments relating to discrimination and harassment related to certain personal characteristics, to increase equality of opportunity, to amend the law relating to rights and responsibilities in family relationships, and for connected purposes. There is a specific section dealing with section 120, which starts at the bottom of that page and tracks over. Paragraph 393, section 120 also gives jurisdiction to employment tribunals to hear complaints relating to breaches of the non-discrimination law. Section 394 is the part to which I have been leading up. This section is designed to replicate the effect of provisions in the previous legislation. So far from there being any suggestion that Parliament had this profound change, and we say socially damaging change, in mind, they were in fact intending to use phrases as they had forever been used, or at least since the time of Lord Jenkins of Hill Head and the Sex Discrimination Act. Equally, there is no material we have found that one must in the modern era call stakeholders had been agitating for this change, or that they required it or needed it. There's equally no evidence they even realized they had it until an ingenious lawyer in the 21st century came up with this argument.
Has there been any agitation on the other side since 2006?
Well, there's always agitation in certain forms of law. No, because the point has, well, there is in the context of this case. We say that the point is a bad one and always has been. One of the things you will know when you come to read the authorities is that in many such cases they are self-represented litigants. And the case may not be argued in the way it is subsequently argued. No doubt in my case that would be an improvement, but nevertheless it's true to say that self-represented litigants don't always take every point available, and they're not always funded to go beyond the Employment Appeal Tribunal. But the short answer to your question is yes, we're agitating to say that it is wrong. The time limits relevant to Equality Act claims are to some extent important. They are not the same as the time limits for judicial review. That judicial review must be made promptly and in any event by the third monthly anniversary of the decision complained of. It is true that discrimination claims must be brought within 3 months, but the statute provides that you can look at a course of conduct over time, which is a very valuable protection, because discrimination may only evidence itself by a pattern, or by repetition, or by a failure to respond to earlier warning shots. So that is an advantage to the claimant or the complainant of proceeding in this forum.
What's the reference?
Section 118, which is MS page 445. We do say that, and we say this with great respect, but firmly, that the Employment Tribunal is better able to do that which it is required to do by Part 5 than the Administrative Court. That's quite apart from being a forum in which there are advantages to individuals taking on corporations. That greater ability comes from the following. First, one is before a panel with 3 life experiences to share and to inform them. Second, discrimination law is the staple of the ET. It is regularly and frequently litigated, even in sensitive, moral, or religious contexts. The ET has shown itself well able to do that. In my supplementary submissions, I cite a couple of examples. I hope I'll be forgiven for not taking you to them in the interests of time. And
Well, you mentioned Embar and Ladili, didn't you?
Yes, and so, yes, various ones, yes. There are cases about civil registrars refusing to perform same-sex marriages and the like. The final reference within the EQA is at section 114, which takes us to MS page number 442. 114.1 sets out, in England and Wales at least, the county court's jurisdiction. Subsection 7 requires that in proceedings in England and Wales on a claim within subsection 1, the power under section 63.1 of the County Courts Act 1984, appointments of assessors, must be exercised unless the judge is satisfied that there are good reasons for not doing so. So a judge in the county court hearing a contravention of Part 3, 4, 6, 7, and the various sections recited at 114.1e must sit with an assessor unless she can describe and set out good reasons that that be not necessary. And as the senior president of the tribunal observed in arguments in the Court of Appeal, the assessors are taken from the employment tribunal panels to which I've taken you. That's Rule 8, the requirement to keep and maintain a panel of tribunal members. That is an express recognition by Parliament that on occasions, and I say this conscious that it may be thought to be presumptuous, the judiciary need help in identifying different cultural norms, practices, and so on in our diverse society. Having made that point, I'll probably tactfully leave it there. You've heard comparatively little thus far on the relative merits of the Administrative Court and the Employment Tribunal as forums for considering discriminatory claims. We stand by that which is said in our printed case, but we do not challenge for one moment that in suitable cases the Administrative Court can adapt what may be called its standard procedures to meet the needs of an individual case. We don't challenge or dispute the observation of Lord Justice Carnwath that in appropriate cases it may hear factual evidence. It does not do so commonly, but it may. It may adapt its standard rules on disclosure. It does not do so commonly, but it may. There may be many ways in which the procedure can be adapted. But once you've done that, it ceases to be recognizable as judicial review. It is what used to be called a writ action. The essential point is that direct discrimination cases will almost always require witnesses. Indirect discrimination may be different. The black letter of a pension policy may on its face indicate that it disadvantages a group of people for their protected characteristic. But direct discrimination will almost always require evidence. And one must...
Unless it's a Birmingham sort of case.
Yes, yes. I say almost always because I'm very nervous about
When you were asking, well, why did this person do what they did? Yes.
Yes.
For the overt criterion.
The remedies offered by judicial review are different and may not be suitable to the needs or wishes of the complainant. The administrative court has no obligation to sit with assessors. Even if it did sit with an assessor, that person would be no part of the decision-making process, but rather would advise and inform. The structure of a judicial review, quite apart from the principles to be applied, would therefore be different from the employment tribunal, and the administrative court has no special expertise in discrimination claims. There are other softer reasons to believe that Parliament would have wished to maintain the jurisdiction of the employment tribunal. Early conciliation is mandatory in the employment tribunal. Reference must be made to ACAS and so on. But I've said all that in writing, and in the interest of time, may I move on to the case of Khan, with which I need to deal. I appreciate that you've already been taken to it. It's at Volume 1, Authorities, tab 10, starting at 825. Just to recap on the regime, there were two classes of list, full registration and limited registration. If an overseas qualified doctor wished to move from one to the other, obviously from limited to full, she would apply. If refused, there was a review board for overseas qualified practitioners that would sit. Contrary to what I think I heard earlier today, that board did not have the power to upset the decision or to change it. It investigated and reported, making recommendations as to what a third person should do, namely the president. But that's the regime that was being considered. I'd invite your attention to a passage that Mr. Bowers didn't read out. It's from the judgment of Lord Justice Neal, and it's at 834, letter L. That seems to me to be the way Parliament has required that this machinery should be operated. It is also to be noted, as Counsel for the General Medical Council pointed out, that Section 29(3) of the Act of 1983 excludes resort to the Review Board in certain circumstances. I can take, by way of example, Section 29(3)(c). A person in whose case a decision falling within subsection 2 above is made shall not be entitled to apply to the Review Board for a decision to be reviewed where the decision relates to the fact that he'd failed to show that he had the necessary knowledge of English. Pausing there, that decision, whatever its reasoning, is every bit as amenable to judicial review as a refusal to register or to expand registration for any other reason. Lord Justice Neal goes on, in such a case, and in other cases set out in Section 29(3), the practitioner retains a right to bring a complaint to the industrial tribunal. The reason for that is simple. There are, in those cases, no proceedings in the nature of an appeal available against the initial decision. And that's the regime that is being considered, and that it is relevant to consider when one comes on to the mention, which there is, of judicial review. Judicial review is seen as a safeguard for procedural default conducted in the course of a statutory mechanism. And these are, of course, statutory mechanisms. In Lord Justice Hoffman's judgment, you've heard, and I won't take you back to it, that his judgment includes the passage that an appeal or proceedings in the nature of appeal are ones which give the opportunity to have the decision reversed. Now, it is probably fair to say that one should not, on either side, read too much into that. But it is not extravagant to say that proceedings in the nature of an appeal that simply allow the decision to annul are not in the nature of an appeal at all. The administrative court cannot overturn decisions on their merits. If you look at the lawfulness, there may be intense scrutiny, there may be relatively relaxed scrutiny, but the fundamental point is it's not a merits-based challenge, albeit that I accept that there is a move towards saying that in certain types of case one may look more closely at the merits.
I mean, there may be an element of circularity in this because if judicial review were in the nature of an appeal, contrary to your case, and if it were not traditionally satisfactory for the purpose of ensuring an effective remedy, one might have to change judicial review. I mean, going back to a case which hasn't been cited, the Manchester City Council and Pinnock, where we dealt with the question of tenants' rights in relation to local authorities, or the rights of persons who didn't have a legal right to remain actually on property in the face of claim for possession by local authority. We said that judicial review had in that context to cover the facts, and it had to cover proportionality of the decision, even if there was a fairly straightforward answer in almost every case. So, I mean, there may be an element of circularity, but it doesn't detract from your argument that perhaps they weren't envisaging by the statute this sort of expansion of judicial review.
No. And more importantly, whilst I accept that if the GMC is right, they may in the end be hoisted with their own petard because judicial review may adapt itself, one wouldn't wish to place one's professional future on that, nor guess how long that might take and how many adjudicated upon cases it would take to establish that.
Or how complicated it would make the proceedings in the administrative court and how frequent, yes.
Staying with the question of Khan, going to 836E. The passage between E to G is important because in that passage, Lord Justice Hoffman looks purposively at what Parliament or why Parliament might have enacted the provisions in the way they did and attributes it to its view that the Industrial Tribunal is often called a specialist tribunal and has undoubted expertise in matters of sex and racial discrimination. Its advantages in providing an effective remedy, therefore, were outweighed by the even greater specialization in a particular field or trade or professional qualification of statutory tribunals. And that, in essence, is our case, that the words by virtue of an enactment are to be construed as referring to a single unitary scheme where you have initial decision, prescribed route of appeal, possibly no further appeal, but overarching that, the protection of judicial review. That system would, we accept, loyally complying with the ratio in Khan, apply, or would indeed oust the jurisdiction of the Employment Tribunal, but we say nothing short of that would have that consequence. My lady, may I take you to my written case, which is at the core bundle, tab case for the respondent, MS, page number 80. You have, I'm sure, read it already. I just wish to say, because I'm going to cede the floor to Mr. Allen in 2 minutes' time, that we stand by the arguments in the totality of that document, but in particular the summary given at paragraph 2, in which we take the point, first, that judicial review is not a process in the nature of an appeal. Second, that it is not a process that, as this phrase is intended to be understood, arises by virtue of an enactment. The reason for which we give at paragraph C, and which commended itself to a unanimous Court of Appeal. At D, we make the point that the historical development, as to which Mr. Allen has more to say, is important because you find the same regime predating and postdating the Supreme Court Act 1981. And we there set those out. And we make the point that Section 31 simply puts on a statutory footing that which pre-existed. I would not go so far as to say, and cannot go so far as to say, that the common law remedy of judicial review exists, but that's not what the statute is getting at. There are, we say, powerful reasons for inferring that was the intention of Parliament. Not the least is the continued expansion of the remit of the Employment Tribunal over about 50 years. But there are also related reasons, particular to the context of discrimination litigation, the imbalance of resources, the fundamental nature of the rights being infringed, that Parliament cannot possibly have intended that those who, or some of those who take action to enforce what they think are their rights, should do so at potential risk of many, if not all, of their assets. The floodgates argument should be rejected as unevidenced. It should also be rejected as unpersuasive, and even if more vexatious litigants will emerge as a result of a proper understanding of the law, so too will a cohort of the justified and the rational and the reasonable. And it is them, as well as to the interests of Dr. Michalak, that I invite the court to have regard. Unless there are matters I can assist you with further, I'll...
It appears not. Thank you very much, Mr. Edis. Mr. Allen.
My Lady, my Lords, I'm not quite sure how long I've got, but I'm hoping until past, possibly slightly after, but it may be that I don't need to take all of that time. The case for the Equality and Human Rights Commission is at MS 3238, and I propose to go through it without reading it all to you, but picking up one or two points in it, and to develop some answers also to some of the points that have been made. We hope that from the Commission's point of view, we can put a little bit more structure on how we've reached the position of having section 120 subsection 7, and we can say a little bit more about the European context within which we say you must now resolve the debate that is between the parties. Can I start by just posing a particular point, though, in response to the way in which the appellant, supported by the other two regulatory bodies, have put the case? There is, it seems to the Commission, a conundrum which is irresolvable at the heart of the case for the appellant. The conundrum can be put in this way. Prior to the 1981 Act, you had the prerogative writs of mandamus, certiorari, and prohibition. There were arguments about the merits or otherwise of possibly having damages claims. Of course, they were not resolved until the 1981 Act. But the conundrum is this.
Damages claims were resolved later.
Quite right, but this doesn't alter the point that I'm about to make about the conundrum. The conundrum is this, that if those principal remedies, the three that I've just mentioned, were sufficient to amount to proceedings in the nature of an appeal, why was it that they were not included specifically in the original Discrimination Acts? There can't be anything special about the word enactment in what was the original provisions in the Race Relations Act, and the Sex Discrimination Act. But they weren't. Now, somehow, magically, when those words changed their name, but not their effect, in the 1981 Act, it is said that they become proceedings in the nature of an appeal. But that can't be right, because otherwise they would have been included in the earlier proceedings in the original Discrimination Acts. They would have said proceedings by way of appeal or in the nature of an appeal, in each case enacted, or where judicial review is available. And it didn't say that. So if Parliament had it in mind that the three prerogative writs gave rise to a proceeding in the nature of appeal, it's obvious that it would have included it in the earlier legislation, but it didn't. That's the conundrum. They can't meet it, and it's a very straightforward way of actually getting to the heart of the issue in this case. There's no doubt at all that modern judicial review is an enacted process, but its content, the three principal remedies at the heart of it, are not that different. There is a developing common law jurisdiction about when they might be applied. Lord Mance has indicated quite rightly there's a developing concept of the circumstances in which those remedies might be applied. Proportionality, for instance, is now thought possibly to be a ground for founding some of those remedies. But the development of the common law isn't at the heart of this. The heart of it is the nature of the remedies that were available. So that's the conundrum that they can't meet. It really is at the heart of their case. Now, I'll put that to one side and take you swiftly through the case for the Commission. And as you can see, we've adopted the summary concepts of an enacted appeal process, appeal being in quotes, as being at the heart of what this is about. We take all the points. You can see this at MS 3241 under the heading 8, the Commission's core submission as to the Parliament's intention, that there are circumstances in which you want to think about more than one jurisdiction. But our submission is that essentially what Parliament had in mind was a body which was either called an appeal body or had a process equivalent to an appeal body, which largely had plenipotentiary powers. Statutory appeals have plenipotentiary powers, and as we shall see in a moment, the kinds of appeal bodies that were being thought about at the time of the original discrimination statutes essentially had plenipotentiary powers. They could give nuanced judgments on appeal in dealing with the qualification issues. And that's not what the administrative court does, and that's why we adopt and echo essentially the conclusions of the Senior President of Tribunals, Sir Ernest Ryder, in his judgment below. I don't need to develop that at any great length. It's all in our case, but I do want to just say a little bit about the Employment Tribunal's jurisdiction. You'll see that under the heading A at little a at 3243. And we make a number of submissions about this. First of all, as many members of this court, I'm not sure if you were all in the fees case, the Unison case, but I know the majority of you were. You will have known just exactly how specialised a forum it is. 40 different enactments and many more different causes of action. I know that the list of those was put in the proceedings in the Unison case, so I've not replicated it in our submission. We've given you the stats about the number of cases that they deal with in this field, which is evidence itself, I think, of its expertise in this field. The core point I want to make under this heading is it's exceedingly odd that it should be suggested that the ET has lost by a sidewind any jurisdiction at all. It's never previously happened to my knowledge. On the contrary, its jurisdiction has been the subject of endless consultation. Now, that isn't a winning point, but it is a big question mark over the appellant's case. Moreover, the tendency has been to take a view that anything that could be dealt with in the employment tribunal away from the administrative court. Ex parte Lavelle is a very good example of that, Mr. Justice Wolfe, as he then was. Another case I might have added to that, of course, was the original ex parte EOC case, the part-time workers case, in which the question of whether part-time workers were within Article 119, Mrs. Day's judicial review was dismissed, saying she should have brought her case in the employment tribunal and not by judicial review. So we move on then to say, let's have a look at the historical background. And you'll see under cross-heading B at 3245, this is set out for you. And that's been dealt with in terms of the 2010 Act. I can pick up one short point that Ms. Callahan raised about the introduction of the word detriment, if you recall that, into section 54. The reason for that is not far and not difficult to find. It is that all the other provisions dealing with work-related discrimination included the word detriment as a wrap-up. And of course, all of these provisions now have to be seen as a transposition of European law. And so if you could get any other detriment in relation to, say, being treated in the workplace, you had to have any other detriment in relation to qualification bodies. So there's nothing terribly clever about that point at all. There's no particular significance in it. The key point is the Equality Act didn't think it was changing anything under section 127. So taking you back to the history of it, this is all set out in the white paper that introduced the 1975 Act, and that's under our cross-heading Equality for Women. It's page 3246. The background to that is the white paper, as I said. There were then problems with what were quaintly called occupational licensing. It got changed to qualification bodies in the course of the bill. Occupational licensing, historically, there were issues like, for instance, whether airline pilots could have men and women in the same cabin, whether taxis could be driven by women at night. Those sorts of issues used to be discussed. All those kinds of qualification issues were in mind at the time back in 1974 when these issues were being looked at. Essentially, they were predominantly overtly discriminatory provisions that were introduced by qualifying bodies in a completely different generation from the one that we currently have. But the importance of the Industrial Tribunal as being the forum was well attested in the white paper at the time. You can see it in the box in paragraph 39. I don't read it out to you there, but it shows that the idea then was that these work-type problems should essentially go there. The white paper did not deal with the question of appeals or processes in the nature of an appeal. Those emerged in the course of the hearings in Parliament, and loyal as I am to the Hansard rule, I've not gone through all of that for you, but what you do find is the discussion of it in current law statutes, and I think I'm just about allowed to tell you this. It's paragraph 49, current law statutes, the reference is in the bundle, and it says, the examples given were where a person's refused qualification, the appeal will, in cases where there already exists a statutory right of appeal, continue to go to the body and not to a tribunal. For example, the Law Society to the Court of Appeal, that's essentially the Master of Rolls' jurisdiction for solicitors, doctors to the Privy Council. I'm not sure if any of you will have done Privy Council doctors' cases, but you might have done. Yes. And the refusal of licensing justices to the Crown Court.
Bets still remain, yes.
That does, yes. So those were the examples.
Where's paragraph 49 to be found?
My lord?
Where is paragraph 49 to be found?
It's at page 3249.
349, thank you.
The reference is, I've given you the reference in the footnote to where you'll find it in the bundle. But that explains the background to the jurisdiction, I think, about as well as anybody can do. And I'm not going to take you through the change in the Supreme Court Act, which is discussed in our case. We do raise some issues about practical considerations, and I just want to put this in absolute context. Appeals and proceedings in the nature of an appeal can deal with appealable points, but qualifying bodies may discriminate in ways which are not related to appealable points. You can have harassment or delay in the process of lodging the appeal. You can have rudeness to black candidates or Christian candidates or Muslim candidates in the process, yet eventually you get a hearing, but that won't necessarily be picked up. But that's still discrimination, and it needs to be remedied. It's absolutely essential. It's stopped. It's not modern Britain at all, not modern United Kingdom. So how is that to be dealt with appropriately? And we have therefore looked at the position of what's called ancillary liability. It's not really fair to call it ancillary liability. It's actually principal liability constructed in a rather complicated way through the interplay of section 109 and 110. And we say it's by no means obvious that that class of case is taken away from the employment tribunal. And we've set out those provisions through to 67. And we say in terms, it's going to be very important that individual liability of discriminating employees within qualification bodies is confronted, and is confronted in the place where it can be confronted, not forced to go into some judicial review process where you're judicially reviewing the qualifying body with an aim really to try and get at someone being rude. It doesn't make any kind of sense in any ordinary case. Now, from there I move on to the European context. And
You're not going to go through the sections in...
Of course
you
not.
just say it's difficult.
It's just difficult, and that's the best point I could make about it. But
It's not a very good basis for construing a statute.
well,
You may have a point, but you may not.
My Lord, it's good to this extent. It is, as I said earlier, that if you've got a clear case of an appeal structure or something in the nature of appeal, then one looks to whether it's got full powers in some way that it can remedy those issues. It doesn't take us very much further with it, but that difficulty has to be confronted as part of the overall approach. I've got little time, and I need to take some time on the European angle, because this is very important indeed. Now, I'll tell you where I'm going in the end of this, because Lord Mance inevitably got there before me, or before I was on my feet, which is to say there are really important European controls on your interpretation. Now, these are parallel controls, and we, as the Commission, say is if you do conclude that these cases have to go to the administrative court, then the administrative court is going to have to change its process very substantially indeed. And there are two reasons for that, or one, depending on how you interpret the European jurisprudence. There's the overall concept of effective judicial control, and within that is the principle of equivalence. And this is set out in our case at some length. You will, I'm sure, in the past have had submissions on both aspects of this. The principle of an effective remedy is grounded in the framework directives. I don't need to read that to you. The obligation is well developed in reams of case law, but it's developed quite a lot over time, and we've set that out. The key case now is Camacho, which we've mentioned, paragraph 73, for those electronically, 3255. Necessary measures to enable all persons who consider themselves wronged to pursue their claims by judicial process, and then the remedies that are necessary are in 30 through to 32. I'm sure I've got the numbering wrong there, because it seems to have gone from 30 to 30 without going into 31. but I haven't got time to open that for you. I just warn you that I may have got a numbering wrong in that passage. It will often include a requirement for financial compensation for the loss and damage sustained as part of ensuring that there's an effective remedy. And then there are the principles of equivalence and effectiveness which come underneath that, which were developed in Pontin, well, fully explained recently in Pontin. That's in paragraph 76 on page 3256. And they must have the genuine dissuasive effect and must be commensurate with the injuries suffered. And of course, the principle of equivalence comes into play. And I just simply say here, you can analyze the principle of equivalence in a number of different ways. Some of these rights you can see as just simply coming out of transposition. For instance, the added word of detriment is that. But of course, equally, you could say these are rights in a case where you don't make an appeal, but it's still a qualifying body, that derive directly from pre-directive jurisprudence. So we simply say that what you can't do is, in a qualifying body's case, is have one system which is less good than the other. You can't do it. It's inconsistent with European law. And so what we've tried to do in the passages from there through to the end of our case is, in quick but adequate, we hope, form, indicate the problems that arise by sending these cases off for judicial review, where it's an equivalence analysis, if I can put it like that. 3259, as you've heard from Ms. Callaghan, Parliament has made it harder to start judicial review proceedings. That's actually why she wants, for her clients, these matters to go there. That's her case. We say that founders immediately on the principle of equivalence. We've got permission under CPR 54.4. The time limit is more stringent. There's no just and equitable extension, which you do have in all employment cases, all work-related cases under Section 123. The papers to be lodged are more extensive. Under, as Mr. Idis has said, under the Employment Tribunal, there is state paid-for conciliation in advance of the hearing in the Employment Tribunal, but not in judicial review. And then in 82, we point out the effect of Section 31, 3C to 3E of the Senior Courts Act. With effect from the 13th of April last year, 2 years ago, no application for judicial review shall be made unless the leave of the court has been obtained, and the court shall not grant leave to make such an application unless it considers the applicant as a sufficient interest. When considering whether to grant leave to make an application, it may of its own motion consider whether the outcome would be substantially different if the conduct complained of had not occurred. So in a case where there's been harassment or bad treatment in the process, but it's doomed to failure, you won't even get your judicial review proceedings off the ground, even though there may be a need for a remedy about the handling of the case. And these provisions, as we say, stand in contrast to the well-established jurisprudence in relation to discrimination claims in the Employment Tribunal that require a fact-sensitive inquiry and that only the rarest cases should be struck out in limine. Can I refer you to An Yanwu at 3397? It's the only case I want to open, I think, and that is at 3397, which is tab 9 in the supplementary bundle. And this was a case about discrimination in the context of student union officers expelled by a university. And the question was whether the student union employed these students. And if you'll turn to Lord Staines's judgment at 3405, at paragraph 24, letter F, discrimination cases are generally fact-sensitive, and their proper determination is always vital in our pluralistic society. In this field, perhaps more than any other, the bias in favour of a claim being examined on the merits or demerits of its particular facts is a matter of high public interest. Against this background, it's necessary to explain why, on the allegations made by the appellants, it would be wrong to strike out their claims against the university. He then went in to discuss it. Lord Staines's approach was adopted by Lord Hope. You'll find that at paragraph 36 on 3409 through to 3410, and by Lord Brown-Wilkinson, but I can't find the reference at the moment. Paragraph 21 at 3404. And that has been a governing rule for discrimination cases ever since. And then we summarised it under the hearing. Legally qualified judge and representatives, Mr. Edis has made the point, specialist panels, and you don't get that in the administrative court. You could, I suppose, get a divisional court in the administrative court of 2 or 3 judges, but they are not specialist members in the sense that they are in the employment tribunal. We make the points about the recommendations. It is true that they've been somewhat attenuated so that the recommendations got to relate to the individual rather than the class at large. But a remedy of a recommendation is enforceable, contrary to what Mr. Bowers said, because if you fail to comply with a recommendation, the tribunal has power to increase the compensation that is available. And I'll ask for I think it's, what's the reference? 124.
Well, we were taken to that.
You can take it from me.
We were taken to it.
Thank you. Then we've got also, importantly, on the remedies of damages in the administrative court, a clear limitation under section 31(2)(a). The review guide, the judicial review guide, says that the court considers it's highly likely the outcome would not be substantially different. The court may refuse to grant any form of relief and must not award damages except in exceptional public interest cases. Now, I suppose you could argue that discrimination cases are always exceptional public interest, and you might have to do that, but you can see immediately it's an extra hurdle that you've got to get over in judicial review proceedings.
Where do we find that guide?
The guide, I'm afraid I've only given you the hot link to,
Okay,
but it's
that's
in the
fine.
footnote, at footnote 35. And the guide is written by the lead judge, Mr. Justice Cranston, together with Mr. Justice Lewis and Mr. Justice Whipple.
Thank you.
The section 31 of the Senior Courts Act, is in the bundle at 3295. You've seen the rules on costs, and I don't need to go through that. And then 94 through to the end, some smaller points, which I don't need to read out to you any further, but they develop the nature of the litigation in the Employment Tribunal. I just want to pick up, if I may, very shortly, some other points that were made in simply a few sentences each that need to be dealt with. Khan, the argument in Khan, I'm sure you've got, was whether or not the fact that you've got a president making a decision as opposed to a committee making a recommendation. You've got 2 parts to it, whether it was in the nature of an appeal. In retrospect, I think I did well to stay on my feet long enough to get all the way through it, because I can see why inevitably it would have been seen as being in the nature of an appeal. We don't disagree with the fact that legislation is always speaking. The issue in this case is not whether or not a different enactment could be brought into place. It's the conundrum that I've already made. There was a reference to Gandhi. I'd like to just put a marker down in relation to that. Gandhi was the doctor's case where there was a qualifications body, if you remember, probably no longer good law. At the time that it was argued, the principle of equivalence was not in play. I argued Gandhi, and I'm 90% certain that I didn't argue equivalence at that time. If you recall, the judgment in that case from Lord Justice Taylor, building on Anderson, the Army case, was simply that they had to take discrimination law into account. They didn't need to think about the remedies part of it. And that probably isn't correct at the moment now. I think the other points have probably been picked up. Burden of proof certainly applies in all cases. Mr. Bowers was on his feet to say that for you. Yes, the recommendation enforcement provision is section 124, subsection 7. It's volume 1, tab 3, MS 451.
And if they don't pay the compensation, well, you have to go to the county court to enforce it, don't you? But that's common with all tribunals.
Absolutely.
They have no coercive powers.
Yeah,
Yes.
it doesn't have power to put in the bailiffs, but it does have a mechanism for making recommendations work. My lady, my lord, I really have rattled through that, and I hope I didn't exhaust you. If there are any questions that the Commission can answer that you wish to ask while I'm on my feet, I'll do my best.
I don't see any questions.
Thank you.
Thank you very much, Mr. Allen. Thank you to the Commission.
Thank you, my lady. If I could organise the reply points under 4 headings. Firstly, construction of section 120, subsection 7. Secondly, employment tribunal procedure. Thirdly, judicial review. And fourthly, the European points. On the construction of section 120, subsection 7, Mr. Edis said that it only applies where you've got an initial decision, a review and an appeal. We say that is a gloss on the statute. In terms of multiplicity of proceedings, neither Mr. Edis nor Mr. Allen, with respect, have managed to address the point that there is likely on their case to be a multiplicity of overlapping jurisdictions of both upstream and final decisions. The reality is that employment tribunals are very difficult to persuade to adjourn cases, particularly cases of discrimination. My learned friend Mr. Edis appeared to suggest that there was a cap of £25,000 in the employment tribunal on unfair dismissal. In fact, that cap is in relation to wrongful dismissal. But even if there were the possibility of adjourning proceedings, it always creates uncertainty for the parties and extra costs of going through that process. On our case, the parties have certainty at the outset. And we do submit, along with Ms. Callahan, that these really are hermetically sealed provisions within the Equality Act. Each aspect has its own enforcement procedure. And section 127 is a unique provision and a sensitive one to seek to resolve what would otherwise be very unusually the multiplicity of proceedings in a professional qualifying body situation. You were taken to the explanatory memorandum so I won't take you back to it, at MS 3246. Very interesting, but absolutely nothing to do with the proper construction of section 127 in our submission. We are not saying, and have never said, that the Equality Act changed the position to render judicial review under section 127. The words are the same before and after the Equality Act. What changed was that the 1981 Act, as has now been accepted by Mr. Edis, put judicial review on a statutory footing and therefore brought it within the scope of the provisions which were already there. Mr. Allen's alleged conundrum is completely off point. We submit that judicial review has always been in the nature of an appeal. What changed in 1981 was it became by virtue of an enactment when the enactment was passed.
Well, I think Mr. Allen's point was, why should that make all the difference?
Well, because it brings it within the subsection.
Well, that's a bit technical. I mean,
well,
why did they have that criterion before if judicial review was an acceptable substitute for the ET? In principle, it is after 1981, you say, and his argument is, well, why not before?
Well, the requirement of the provision was that it arise by virtue of an enactment, not that it be created by an enactment in any event. And before 1981, it was a common law position, but that's why we place reliance on the Act always being speaking. And Mr. Allen's suggestion that there's a need for plenipotentiary power is also a gloss. The reference to the white paper on the occupational licensing provisions, again, says nothing about the predecessor of section 120, subsection 7, nor does the current law statutes. On employment tribunal procedure, the second point I wish to respond to, there is a real issue about vexatious complaints. Now, I accept that I can't point to a research project which analyzes this, but you've had counsel on behalf of 3 of the major professional bodies explaining to the court how it is a problem. There are within the bundles 3 cases, admittedly only at employment tribunal level, which relate a series of unmeritorious applications against appeal bodies. If I may just give you the tab numbers, please. Tab 50, a case called Harold. Tab 53, a case called Otobo. And tab 52, a case called Ota. So now what is suggested is that the employment tribunal will strike out an unmeritorious claim under Rule 37. In the light of Annuano, the case that is at Supplementary Bundle 9, page 3405, paragraph 24, that simply does not happen, because inevitably a discrimination case is seen as being fact sensitive. I can't think of a single case since that has been struck out. And in our submission, it does point up the real difficulty where you are contrasting a provision with permission, as in judicial review, as against the employment tribunal. And the suggestion that on a paper sift, a tribunal would sift out cases is similarly unrealistic. Deposit orders are made sometimes. I'm not aware of statistics which are kept on that, but a deposit order is simply that the claimant is asked for a deposit, and if he or she provides the deposit, the case goes on.
Mr. Howes, you gave us the reference to those three cases. I was quickly looking at Oka and Matobo, wondering whether a vexatious claim had gone on and on and on. But they were both struck out.
Sorry? I think Mr. Solomon was in
Well, then he would know.
those cases, and that was after very lengthy hearings, I'm told.
Or maybe nobody thought it was going to be so complicated to strike out claims in the ET in 1981, and annuano wasn't until 2001.
My Lord, it has
I mean,
always...
the rules there, and presumably it was thought that it would be effective, but may not have...
It has always been difficult to strike out cases in the employment tribunal, particularly discrimination, but annuano puts that on the level of a House of Lords authority and has made it more difficult. In terms of JR, if I may respectfully make a few points on that. Firstly, the costs of JR in a suitable case, the court may make a cost protection order, but in any event, the costs in relation to qualifying bodies will normally be paid by people who are members of a defence union, and that should be taken into account, that unlike some other cases, the playing field on costs is more level in such cases. We do submit that judicial review is increasingly going into merits, particularly on proportionality issues. We also submit that, and I won't take you to it given the time, but if I may give you the reference, that in any case on JR, in addition to the terms of the Gandhi case, that the court must take into account the provisions of the discrimination provisions. The case of Anderson, which is at bundle 3, tab 57, page 1663, says that the court should also decide whether it's an appropriate case to grant damages. We also submit that section 31(5)(a) does apply in a medical case. That is to be found, we don't need to turn to it, at volume 1, tab 7, page 653. We would submit that the GMC itself is not a court or a tribunal. We would accept that. But the medical practitioner tribunal or the interim orders tribunals are tribunals. They're set up as crazy judicial, well, probably judicial bodies. As to time scale, it's routine to extend time in judicial review cases. So we see no difference there. As to specialists, the Judicial Review Court can, although I accept it's very rare, but if the judge thought it appropriate, sit with assessors. As to the early conciliation point, it is true that ACAS does not get involved in judicial review claims, but of course under the pre-action protocol, which is in the bundle 2, divider 16, page 1015, paragraph 9, early conciliation is also required. Can I finally deal with the EU point? In our submission, this should not form the basis of any judgment of the court. This was not raised in the EAT, Court of Appeal. There is no respondent's notice. In our submission, it is inappropriate that it be raised now. If, however, the court were minded to accept that it is appropriate for an intervener at the last minute to raise the matter, we would simply say that there is no basis for suggesting, which is what is being said, that judicial review is not sufficiently dissuasive to come within the provisions of European law. We say that judicial review is a real and effective judicial protection, particularly bearing in mind the need in judicial review to consider the discrimination provisions, and we rely there on the Gandhi case and on Anderson. And we also rely on the fact that the cases demonstrate that the member state doesn't have to give the very best remedies in any event. But what we say is that there's no basis, and indeed it would be a very wide-ranging decision to say that judicial review does not satisfy the terms of discrimination. And if I may take the same jury point that's been taken against me, it's not something that, as far as I'm aware, has been raised in however many decades it is since these EU provisions came into force. May I just check? Unless there are any matters that court...
No, thank you very much indeed, Mr. Bowers. Well, we're very grateful to everybody. We're particularly grateful to the main parties to the case who were kind enough to cede 10 minutes of their time to each of the interveners. We're grateful to the interveners because obviously they have alerted us to the wider issue of the case, and it's not just about the Medical Act and all of the other things, and that's very important for us when we consider the issues. We shall now, of course, go away and try and work out what the answer to the conundrum is.
Lady, forgive me. I did cite or refer to two authorities that are not in your bundle.
You did indeed, yes.
Shall we provide them within a couple of days?
That would be very helpful. And perhaps if you could do it electronically as well as in hard copy, Lord Kerr and I would be most grateful.
All be grateful.
Thank you. Court is now adjourned.